Welcome to Vital Signs and Verdicts, where medicine meets the law and the truth gets put under the microscope. I'm Liam, a former hospital administrator turned whistleblower, and your host. I'm joined by my co-host Sarah, a former press secretary to a governor with a background in public relations and law, and our panel. Hope, a former surgical RN who lived through her own systemic failure. Pete, who holds a doctorate in psychology and helps firms pick juries for high-profile cases. And Dr. Tyler, a medical doctor with a Juris Doctorate who has testified in federal court and before Congress.
Before we begin, everything we discuss today reflects our professional opinions based on publicly available information, including the court filings in this case. Nothing here is legal advice, medical advice, or a statement of fact beyond what is documented in those filings.
Today, we're diving into the questions people keep asking but rarely get straight answers to. Organ procurement, medical records, billing fraud, retaliation, and why so many families feel the system is stacked against them.
These aren't abstract issues. They're tied to real cases, real investigations, and real failures. And many of these questions have been raised because of a very public, historic case unfolding right here in our own backyard. Richardson Edmonds versus Cox Health and Cox Medical Center Branson.
When we say historic, it's because this is the widow of a decorated Gulf War veteran who has run into wall after wall and has chosen, at least for now, to take on $1 billion healthcare system with endless resources entirely on her own. She is fighting this pro se, meaning she is acting as her own lawyer, without a 1,000-man firm or the finances Cox Health has, making the stakes and circumstances surrounding this case undeniably intriguing and potentially groundbreaking.
She's received some backlash, though most public comments have been overwhelmingly supportive. But in reading those comments, we realized the public has real questions, real confusion, and real concerns. And today, we're going to address the issues people are most curious about.
And we're going to separate what's real from what's exaggerated.
We are going to do it using the law, the medicine, and the documented facts.
Plus, we are going to talk about what actually happens to patients and families, because that's why I left nursing. The system failed too many people, including myself.
Let's start with the question that gets the emotions burning and the conversations heated that's been sent to us more than any other. Unauthorized organ preparation. And when we say unauthorized organ preparation, we are talking about processes that would ensure safer delivery and viability of organs if they were to be procured.
Unauthorized organ prep looks like seeing treatments that don't match the plan the family was told. If a patient is supposedly on palliative care but suddenly has 4 different broad-spectrum antibiotics, electrolyte balancing drips, vasopressors, and even donor-specific eye drops, that's not palliative care. That's organ optimization.
Or it could just be sloppy charting or a doctor being overly cautious. Families don't always understand why certain meds are used.
Sloppy charting doesn't explain donor-specific protocols. Palliative care doesn't include kidney preservation antibiotics or lung protective bronchodilators if the stated goal is comfort. But the orders look like they're trying to keep organs viable. That's not caution, that's preparation.
But families aren't clinicians. How would they know the difference?
Because the treatments don't match the story they're being told. If a family is told, we're focusing on comfort, but the chart shows aggressive organ preservation meds, that contradiction is the signal. Comfort care is morphine and symptom control. Organ prep is antibiotics, vasopressors, fluids, and optimization. When the care plan doesn't match the prognosis, that's the red flag.
It's not about guessing intent. It's about recognizing when the treatment plan shifts from caring for the patient to preserving the organs before the determination is final.
Okay, but take the Cox Health case. The plaintiff says paralytics were used when the patient wasn't even on a vent. Does that have anything to do with organ preservation?
Paralytics have nothing to do with comfort care, and they have nothing to do with treating the underlying condition, but they do keep a body still. In organ procurement, paralytics are sometimes used to prevent movement during optimization.
If a patient isn't on a vent and isn't supposed to be undergoing any procedure that requires paralysis, seeing paralytics on the MAR is a major red flag.
But couldn't that still be a mistake or a miscommunication?
Not when you pair it with the rest of the orders: paralytics plus broad-spectrum antibiotics, electrolyte correction, vasopressors, and donor-specific eye drops. That's not a treatment plan. That's an optimization plan. And if the family was told the patient was on palliative care, none of those medications make sense unless someone was preparing the organs, not the patient.
And paralytics without ventilation eliminate the possibility that any movement is voluntary. That matters.
So you're saying the medication list tells the real story.
Exactly. Families hear comfort care, but the chart shows organ preservation. When the meds don't match the message, that's when you know something is wrong.
The Hoover case in Kentucky is one example. Declared brain dead, prepped for organ retrieval, and then he started moving and crying on the table.
And a surgeon refused to proceed.
And Hoover survived. That alone shows the determination process was flawed.
Or it shows the determination process was rushed.
That's the same thing, Pete.
No, it's not. One implies incompetence. The other implies pressure.
Both are failures.
Then there's the Larry Black case in St. Louis. Shot in the head, prepped for organ harvesting, and a neurosurgeon stopped it because he wasn't brain dead.
And he recovered. That should never happen if the system is functioning correctly.
And then the HRSA investigation, 73 cases in Kentucky, where procurement was nearly initiated despite signs of consciousness, and those were discovered less than a year ago.
Some of those patients were discharged.
These aren't rumors. These are documented failures.
And I'll add something from inside the system. When a hospital is under pressure to meet organ donation metrics, the conversations behind closed doors change. The language shifts from, is this patient recoverable, to is this patient eligible, long before it should.
That's exactly what I saw. Families weren't given time. Nurses weren't given time. The system moved faster than the patient's condition.
Or faster than the truth.
That's not a psychological issue. That's procedural.
Everything is psychological when you're dealing with families in crisis.
Not when the issue is a flawed neurological exam.
Caller 1, you're on.
How do I know this won't happen to my mom in the ICU?
You ask questions. You don't let anyone rush you.
You confirm who is making the neurological determination and whether the criteria have been met.
And you document every conversation.
Caller 2, go ahead.
Is this happening everywhere?
No, but it happens enough that pretending it never happens is irresponsible.
One case is enough to destroy a family.
Let's talk about why these failures happen.
Pressure from performance quotas. OPOs were graded on transplant numbers starting in 2020.
And that created a high-pressure environment to secure organs.
And drug mimicry. Overdoses can look like brain death if the washout period isn't followed.
When Hope says drug mimicry, she means certain substances can make a patient look neurologically absent when they're not. Overdoses, sedatives, benzos, opioids, and paralytics can suppress reflexes, breathing, and responsiveness if the washout period isn't followed. The exam can look like brain death even though the drugs are still active.
So you're saying the patient isn't actually brain dead? They're just chemically shut down.
Exactly. And if you don't wait long enough for the drugs to clear, the exam is meaningless. You can't test a nervous system that's still under the influence.
And that's why rushing the determination is dangerous. If the patient still has drugs on board, you're not assessing their brain, you're assessing the medication.
But hospitals know this. Why would they skip the washout?
Time pressure, organ viability windows, staffing, miscommunication, or someone assuming the dose wasn't high enough to matter, but it matters every time.
And families aren't told any of that. They're told the patient isn't responding. They're not told the patient might still be metabolizing the drugs.
So drug mimicry can make a living patient look like a donor candidate.
If the washout period isn't followed, yes.
And DCD cases. Life support is withdrawn, and the team waits for the heart to stop. But sometimes the patient keeps breathing.
And conflict of interest. OPO staff stepping into cases too early.
Families being approached before a final neurological prognosis.
That's a structural problem.
And it's why people don't trust the system.
Or the people running it.
That's unnecessary.
No, it's accurate.
You're implying intent.
I'm implying pressure. You're the one hearing intent.
Caller 3, you're on.
Why does it feel like hospitals rush families?
Because they do. Not always maliciously, but the system is built around speed.
And around metrics.
And around organ viability windows.
Which doesn't help families who need time to think.
And I'll add this. Internal meetings often focus on timelines and coordination windows. Families aren't told that. Staff aren't told the whole picture, but administrators are.
And nurses are the ones caught in the middle.
Let's move to medical record tampering.
Federal law makes falsifying medical records a crime. States have their own penalties, including license suspension.
And it happens more than people think.
And when it happens, it's usually to cover liability.
Or to align documentation with what should have happened instead of what did.
That's a nice way of saying covering tracks.
It's a legal way of saying it.
Exactly my point.
Caller 4, you're on.
Do hospitals change records to hide mistakes?
Intentionally? Rare, but it happens, and when it does, the consequences are severe.
Most edits are normal. The illegal ones are the ones made after the fact to hide something.
And courts take that seriously.
And from the administrative side, I can tell you this. When an incident happens, the first question isn't what went wrong, it's what's documented. That tells you everything.
That's why I left, that exact mindset.
Let's talk about billing fraud.
Upcoding, unbundling, phantom billing, unnecessary services, kickbacks.
The False Claims Act is the main enforcement tool.
And the money involved is massive.
And patients get hurt when unnecessary procedures are done.
Caller 5, go ahead.
Why does billing fraud keep happening?
Because the financial incentives are enormous.
And because some organizations build it into their business model.
And because enforcement is reactive, not proactive.
Well, and face it, patients don't know what they're being billed for. That is why often there are so many diagnosis codes to justify the bill to the insurance company.
Medical billing has become an art form.
Now let's address the broader questions. Is there a theme behind patient complaints?
Yes, people feel ignored, dismissed, and powerless.
And when people feel powerless, they assume the worst.
And sometimes the worst is justified.
What about retaliation and why so many say they can't get an attorney for their case?
Hospitals retaliate in subtle ways. Access restrictions, communication barriers, sudden policy enforcement.
And staff face retaliation too. I lived it.
Families struggle to find attorneys because medical cases are expensive, not because they lack merit.
And incident reports and internal communications are excluded from discovery because they're protected under quality assurance laws.
Which doesn't help families who want answers.
Now the questions from commenters who disagreed. You all have some questions in front of you. Sarah, let's start with you. People just sue for money.
The filings show record discrepancies, withheld materials, and billing irregularities.
Hope, this is all about money.
The lawsuit includes non-financial claims.
Pete, hundreds of people are lying.
That right there is statistically impossible.
Tyler, this is normal restraint protocol.
This one really bothers me. Restraints are a last option, and even then, restraints are not to be used without capacity documentation.
Sarah, hospitals never alter records.
False. There are too many documented cases of this, as a practice that happens far too often.
Hope, organ harvesting doesn't happen in the U.S.?
Once again, the findings from the HHS last summer and other documented cases say otherwise.
Tyler, if lawyers won't take a case, nothing happened.
Like I stated earlier, that is just incorrect.
Pete, this is just one family's story.
The petition has over 700 submissions.
Let's talk about something people keep asking. Why is this plaintiff doing this pro se?
From a psychological standpoint, going pro se can mean she feels no one else will fight for her the way she will. It can also mean she doesn't trust the system, which isn't uncommon when someone feels betrayed by an institution.
Or it can mean something far simpler. She knows she's smart enough to take this hospital on, and she knows that if she hired an attorney, they would tell her to stop speaking publicly. They'd shut down her transparency, her advocacy, and her ability to draw out other alleged victims. It gives her control and leverage.
But attorneys exist for a reason. Most people don't take on billion-dollar systems alone. In fact, I have never heard of one.
Unless they have to. And let's be honest, conflict of interest is real. If the hospital consulted with certain firms, or if family members work there, or if the legal community is tightly connected, she may not have had a conflict-free option. Sometimes pro-SE isn't a choice. It's the only path left.
And sometimes it's both. She may not have found conflict-free representation, and she may also believe she can articulate her husband's story better than anyone else. That doesn't make her reckless. It makes her determined.
Determined can still be emotional.
Emotional doesn't mean wrong, and it doesn't mean incapable. It means she's human, and she's navigating a system that wasn't built to make this easy.
Caller, you're on.
Enough with this woman and this case. This story is all over the place. Her husband probably died of a drug overdose, and she just needs to get over it already. Pull up her big girl panties, go to church, be thankful, and shut her mouth up.
That's exactly why people stay silent, comments like that. But the medical records don't show a drug overdose as the cause of death, and the discharge doctor didn't list meth as a contributing factor. That was added later, after the coroner pulled the hospital's files. Those are facts, not emotions.
And psychologically, dismissing someone's grief doesn't make the facts disappear. It just shows how uncomfortable people are with stories that challenge their assumptions.
And let's be clear, telling a widow to get over it isn't an argument, it's avoidance. If someone wants to dispute the case, they should dispute the documentation, the timelines, the procedures, not her character.
And the idea that she should be quiet because it makes people uncomfortable? That's exactly why she went public. Silence protects institutions, not families.
And we have another comment caller. You are on the air.
This woman suing Cox obviously has some sort of agenda. 13 counts. All this happened to one person. She just wants attention.
13 counts doesn't mean 13 fantasies. It means 13 alleged failures. When a system breaks, it rarely breaks in just one place.
And anyone who's worked in healthcare knows that when something goes wrong, it usually triggers a cascade. One error leads to another. One oversight creates 3 more. 13 isn't excessive, it's realistic.
And from a psychological perspective, people say she wants attention because it's easier than accepting that something this big could happen. It's a defense mechanism.
The quote-unquote agenda argument falls apart when you look at the fact she's doing this alone, without a lawyer, against a billion-dollar institution. That's not attention-seeking, that's courage.
The public should care because if even half of what she alleges is true, it exposes systemic issues that affect every family in this region.
Caller 6, you're on.
Why on earth did this plaintiff go so public with this, and why should the public care?
Because staying quiet only protects the institution. Going public early forced transparency before the hospital could control the narrative. It's unconventional, but it's been the only leverage against a billion-dollar company with unlimited resources. When a case is this big, silence helps the system. Public attention helps the patient.
And public pressure changes behavior faster than litigation. Courts move slowly. Media doesn't.
If this had stayed private, it would have been buried under internal reviews, confidentiality policies, and PR statements. By going public, the plaintiff made sure the facts couldn't be quietly managed. And the public should care, because the patterns in this case aren't unique. If it can happen once, it can happen anywhere.
So the publicity isn't about drama. It's about survival. It's about accountability. When the system is this big, the only thing that balances it is public awareness.
Because any family can end up in this position.
Transparency protects everyone, and
Systems don't fix themselves.
Ignoring patterns guarantees they repeat.
Caller 7, you are on with vital signs and verdicts. What is your question?
I'm calling because this happened to me. I went into the hospital for a hernia operation. I was there 6 days. I smoked pot back then, nothing else. But when I applied for disability later and got my records, it showed I tested positive for meth and amphetamines during that stay, but not THC. I never touched meth in my life. I even paid for a hair follicle test, and it completely disproves their results. But the hospital refuses to change the record. I'm hitting a brick wall. Why would they do that? I'm honestly thinking about taking them to court.
Or, and I'm just playing devil's advocate, maybe it was a lab error or a mix-up. Hospitals aren't out here planting meth results on random patients.
lab errors don't selectively erase THC. While repeatedly showing meth and amphetamines, THC is detectable far longer than amphetamines. If she smoked pot, THC should be there. If she never used meth, meth shouldn't be, and a hair follicle test is far more reliable for long-term detection. When the hospital's results contradict both pharmacology and independent testing, that's not a mix-up. That's a documentation problem.
But why would a hospital dig in and refuse to correct it?
Because once a diagnosis or tox result is in the chart, changing it means admitting the original documentation was wrong, and hospitals avoid that. It opens the door to liability, quality of care questions, and internal reviews. They're not thinking about her reputation, they're thinking about protecting themselves.
So you're saying the refusal is about the system, not the patient.
Exactly, and the pattern matters. If the tox results don't match the patient's history, don't match the pharmacology, and don't match the independent testing, the burden isn't on the patient to prove innocence. It's on the institution to explain the inconsistency.
And patients don't know they can challenge it. They assume the hospital must be right. But when the numbers don't behave the way the drug should, that's when you question the record. not the patient.
And there's another layer people don't realize. Hospitals use aggregated diagnosis data, including substance use diagnoses, to justify certain grants, community health funding, and federal dollars. I'm not saying that's what happened here, but I am saying the incentives exist.
Exactly. When a region is classified as high impact for meth use, higher documented rates of meth-positive patients strengthen applications for behavioral health grants, emergency preparedness funding, and community health needs assessments. The data becomes part of the hospital's financial narrative.
So a wrong diagnosis doesn't just hurt the patient. It helps the hospital.
It can. And that's why these cases deserve scrutiny.
And why patients like her shouldn't be dismissed. When the story doesn't match the science, you listen to the patient.
Caller 8, you are up.
Why are so many people coming forward now?
Because one story gives others permission to speak.
And because people recognize patterns.
I also think it's because the legal system is finally paying attention.
And because silence protects the wrong people.
That is all that we have for right now. We will keep the conversation going on our Facebook page. If you have a question or would like to comment, we may air it. This has been Vital Signs and Verdicts. We'll continue this conversation next time.